Hello, my name is Narissa Ferry and I'm one of the Medico-legal advisors at MDA National. As we move into another year of the COVID pandemic, it's a good opportunity for us to reflect on the challenges facing our doctor members and in particular our hardworking orthopaedic surgeons. As a member-owned organisation, it's really important for us to engage with you in a way that adds value to your practice. While we would prefer to see you face-to-face, another year of COVID has sadly sent us back to our screens, but I'm very pleased to be able to present a year in review on behalf of the entire professional services team. On the regulatory front, we've seen changes in the way that AHPRA conducts its investigations in an effort to deal with notifications in a more efficient manner. AHPRA will now call practitioners for a telephone discussion while a notification is in the triage or assessment stage. This is likely to be the first time you become aware of the notification. And while it's the intention to streamline the process for low-level matters, this step is voluntary and practitioners should remain cautious about the extent to which they provide a verbal response. We recommend you seek advice from MDA before speaking to AHPRA, as file notes of these conversations will be retained and they can be relied upon as evidence in an investigation. We've also seen an increase in the number of practitioners being compelled to attend interviews under Schedule 5 of the national law. Schedule 5 interviews are requested for matters that are already under investigation, so this is not a power that AHPRA will use at the beginning of the notification process. The interviews can be lengthy and confronting for practitioners because they're often put on the spot and they don't have an opportunity to seek legal advice before answering questions. The questions can be open-ended, which can lead to practitioners saying more than they need to and potentially making them vulnerable to further investigation. In the past, AHPRA rarely compelled interviews under Schedule 5, preferring practitioners to respond in writing, which allowed time to obtain considered legal advice and ensured that practitioners had a proper opportunity to consult notes, reflect on their response, and undertake education. Unfortunately, the legislation leaves very little room for practitioners to be excused from attending these interviews, so we encourage you to seek advice from MDA before participating in a Schedule 5 interview. Other changes include the establishment of triage committees to assist in expediting matters before the board. Triage committees are delegates of the medical board and convene on a more regular basis than other delegates. AHPRA also has a dedicated COVID-19 team to respond to concerns relating to the pandemic. This team deals with notifications about practitioners issuing vaccination or mask exemptions against ATAGI and other government advice, doctors who are critical of the public health response to the pandemic, and other related complaints. This team tends to act quickly and seeks an explanation of any reported conduct or performance with the goal of ensuring that health practitioners are supporting public health efforts. The national boards have published guidelines regarding the expected role of health practitioners, and we encourage you to visit the AHPRA website if you'd like more information. According to the annual report for the Medical Board of Australia for 2021, 5,516 notifications were lodged with AHPRA, which represented 5.7% of the profession. The most common types of complaints related to clinical care, communication, and medication. No further action was taken in relation to 71% of notifications, conditions were imposed on 6% of notifications, and 0.4% had their registration suspended, cancelled or surrendered. The Medico-legal team has noticed a gradual increase in the number of queries received via email, online notifications and live chat. Unsurprisingly, given the sensitive and often complex nature of medico-legal queries, phone is still by far the most common means of contact for our members, regardless of age or stage of career. In the past 12 months, we've received around 12,000 new notifications, with around 20% of those triggering the policy. Despite the pandemic, it's largely business as usual in terms of queries, claims and investigations. If anything, COVID has just added an extra layer of complexity for everyone involved. We've seen COVID queries vary between the states and territories as public health orders and mandates have been amended and borders have gradually come down. In addition to providing personalised and tailored advice to individual members and practices, we've regularly updated our dedicated COVID webpage for ease of access. We certainly don't underestimate the additional pressure the pandemic has placed on doctors and their practice staff, both personally and professionally. Keep an eye out for our upcoming winter edition of Defence Update, which includes a feature pull-out on managing challenging patient interactions during COVID-19. Other common medico-legal themes are around the perennial issues: privacy and confidentiality, the release of patient notes, family disputes and deceased estates, requests for medico-legal reports, employment queries, subpoenas to give evidence, and ending the doctor-patient relationship. Surgical complications are still by far the most common case types we see for orthopaedic surgeons, followed by diagnosis, treatment, and general duty of care. A third of all matters relate to investigations by the medical board, while a further 20% involved investigations by the coroner. Medico-legal advisory services work closely with the team from Support in Practice, who help members to avoid claims and complaints by providing advice about practice systems and processes. One area where Support in Practice has a lot of experience and expertise is on the topic of informed consent, which is something that orthopaedic surgeons generally do really well. For there to be valid informed consent, the patient must have the legal capacity to consent, give their consent voluntarily for the specific treatment or procedure, have enough information about their condition, the treatment options, the benefits and risks, and any alternatives available to them, which includes an opportunity to ask questions and discuss. We've also received excellent feedback on a recent article from Defence Update on shared decision-making. Implementing shared decision-making is essential to enabling a patient's preferences to be incorporated into a consultation, improving patient knowledge, risk perception, accuracy, and patient-clinician communication. You can find part 2 of this excellent series in the upcoming winter edition of Defence Update, where we address the common barriers and misconceptions. Our Education Services team also recommend you keep an eye out for an educational debate about facilitating patient autonomy. This debate is an opportunity to reflect on your work, biases, values and communication, and be inspired to strengthen a patient's ability to make genuine, voluntary and informed decisions that align with what is sensible and meaningful for them. Our upcoming edition of Defence Update also includes an excellent article on second opinions. The term second opinion has traditionally been used when a doctor seeks the opinion of a colleague to assist in a patient's management, but of course a second opinion can also be requested by a patient, and this is anticipated in the Code of Conduct for doctors in Australia. If you are being asked to provide a second opinion, it's important to respect not only the patient, but also the initial treating doctor. Disparaging and off-the-cuff comments can lead to a complaint or claim against the initial treating doctor, even when the care provided was entirely appropriate. Second opinions can be helpful to both patients and doctors to provide reassurance or to give a fresh perspective on a complex or difficult clinical situation. It's important to keep the patient's best interests in mind with clear expectations and communicate courteously with both patients and colleagues. Some of the lesser known issues for surgeons, but of importance nonetheless, involve investigations into the use of clinical photography and social media. There are a number of important considerations when deciding whether clinical photography is appropriate. Will the patient benefit from the clinical image? Will you use your personal mobile, and if so, does the hospital have any policies that you need to be aware of? You can take an image for the purpose of teaching, training or research, provided the appropriate consent is obtained. If using your personal mobile, you must obtain written consent from the patient and note who recorded the image, where it was recorded, and the mode of capture. Images are part of the clinical record and should be transferred to the patient's notes and deleted from any personal mobile device once this has been done. We also recommend doctors take care when responding to comments on social media or to negative online reviews. There are a number of potential pitfalls, such as breaches of patient privacy, workplace policies, or the Code of Conduct. Get advice and think before you post. We've also just received notice that the Department of Health are currently targeting orthopaedic surgeons with regards to the billing of multiple procedures, hips and knees. If you receive one of these targeted compliance letters, please contact MDA National for advice. We are all very relieved that travel is finally back on the table. And while it's great to get away and recharge your batteries, it's also a timely reminder about some of the common risks of poorly managed leave. You can read my article on surgeons and holidays, what are the risks, for some practical tips on how you can reduce the chance of a complaint or a claim. Now, this brings us to the end of your year in review. So thank you for the excellent care that you have provided to your patients during the pandemic. All the best for the remainder of the year, and thank you for trusting us to be your preferred medico-legal provider.